So it's Sunday, March 14th. Plenty of news to get to. Courts are starting to open slightly here in Rochester. The hardship declarations are starting to roll in. And this past Friday, a few housing providers, including myself across New York, filed suit against New York. Let's get to it. You like the new intro? I'm pretty pumped about it. So, first, with regards to the courts being opened, so I'm going to take one step back, and I'm going to post this up on the screen. Hopefully, it's going to look decent for you. I'm getting a little used to this new software I'm using, but I want to read you from the COVID-19 Emergency Eviction and Foreclosure Prevention Act of 2020 to give you a little bit of background as to what's going on. So, as it says, the COVID Emergency Eviction and Foreclosure Prevention Act of 2020 ensures New York renters and homeowners impacted by the COVID-19 pandemic can safely remain in their homes. The act suspends eviction and foreclosure proceedings for 60 days to give renters and homeowners the opportunity to submit a hardship declaration. If you face eviction or foreclosure from the loss of income or increased costs due to the COVID-19 pandemic, select and submit the applicable hardship declaration below. Now, here's the part that kind of gets me. Residential eviction proceeding pending on December 28, 2020, including eviction proceedings filed on or before March 7, 2020, and any residential eviction proceeding commenced on or before January 27, 2021 shall be stayed for 60 days. Now, this is directly from the New York State Senate's website. I'm going to put a link in the description below. Renters who have lost income or are unable to pay increased costs or are unable to move without significant risk to their health or the health of a family member can declare hardship and protect themselves against eviction until May 1st, 2021. Tenants should sign and deliver to their landlord a hardship declaration form. For the duration of hardship, tenants cannot be evicted for non-payment of rent or for remaining in the property after the expiration of your lease. Persistent behavior that puts other tenants or occupants at risk are grounds for eviction. So, as many of us have been complaining all along, our biggest gripe is the fact that the courts have not given us access. We have not had access to the courts or due process to verify whether or not people have been impacted financially. And I know I've said it a million times and you're sick of hearing it, but I'll say it again. I don't want to evict people. I really don't. Most housing providers I've talked to do not want to evict people. It's actually literally the last thing that we want to do. We buy property to have people rent from us, to provide housing opportunities, because that's how we pay the bills. We're not just gathering properties for the sake of having vacant properties to stare at. We need good tenants, and tenants need good housing providers. It's a very connected relationship. So again, I don't want to evict people, and I am not evicting people, haven't even started an eviction proceeding or even mentioned an eviction proceeding to anyone who has truly been impacted financially by COVID. People that came to me, showed me that they were, we discussed it, we said we're gonna find a way to work through it. The only people that I want to evict right now are people that I know have had no interruption in income and are choosing not to pay rent because of the Tenant Protection Act, they know the recourse that I'm going to have available to me on the other side of this is essentially useless, or at least it's not going to impact them and their circumstance. So the idea that we've got to provide a hardship declaration to folks, which is essentially going to stop the eviction proceeding. It's going to deny myself, along with any other housing provider that receives one, due process. It's going to deny us the access to the courts for due process. And here's the thing that just doesn't make any sense and hasn't made any sense all along. If they've truly been impacted financially by COVID, they should be applying for and they should be qualified for the relief. As I understand it, and the number changes depending on who I talk to, there are millions of dollars still sitting in New York coffers for relief that has not been spent yet. So the only reason that people aren't accessing that relief, from what I can tell, and from what most people can tell, is because they're not qualified for it. What would lead someone to not be qualified for relief? The fact that they haven't experienced any financial hardship. Now, I'm going to show you, I'm going to throw it up on the screen, and again, I hope it comes through well. I want to show you what these hardship declarations look like, and then we can discuss it a bit further. So the first one is the Tenant's Declaration of Hardship during the COVID-19 pandemic. Not the first one, the form, I should say, is the Tenant's Declaration of Hardship during the COVID-19 pandemic. And as it reads, I am a tenant, lawful occupant, or other person responsible for paying rent, use and occupancy, or other financial obligation under a lease or tenancy agreement at address, or dwelling unit, fill in the blank. You must indicate below your qualification for eviction protection by selecting option A or B or both. Selection A, I am experiencing financial hardship and I am unable to pay my rent or other financial obligations under the lease in full or obtain alternative suitable permanent housing because of one or more of the following. 1. Significant loss of household income during the COVID-19 pandemic. 2. Increase in necessary out-of-pocket expenses related to performing essential work or related to health impacts during the COVID-19 pandemic. 3. Child care responsibilities or responsibilities to care for an elderly, disabled, or sick family member during the COVID-19 pandemic have negatively affected my ability or the ability of someone in my household to obtain meaningful employment or earn income or increased my necessary out-of-pocket expenses. 4. Moving expenses and difficulty I have securing alternative housing make it a hardship for me to relocate to another residence during the COVID-19 pandemic. 5. Other circumstances related to the COVID-19 pandemic have negatively affected my ability to obtain meaningful employment or earn income or have significantly reduced my household income or significantly increased my expenses. Now the second part goes on. To the extent that I have lost household income or had increased expenses, any public assistance, including unemployment insurance, pandemic unemployment assistance, disability insurance, or paid family leave that I have received since the start of the COVID-19 pandemic does not fully make up for my loss of household income or increased expenses. B, vacating the premise and moving into a new permanent housing would pose a significant health risk because I or one or more members of my household have an increased risk for illness, severe illness rather, or death from COVID-19 due to being over the age of 65, having a disability or having an underlying medical condition, which may include but is not limited to being immunocompromised. I understand that I must comply with all other lawful terms of my under my tenancy, lease agreement, or similar contract. I further understand that lawful fees, penalties, or interest for not having paid rent in full or met other financial obligation as required by my tenancy, lease agreement, or similar contract may still be charged or collected and may result in a monetary judgment against me. I further understand that my landlord may be able to seek eviction after May 1st, 2021, and that the law may provide certain protections at that time that are separate from those available through this declaration. Signed, printed name, date. Notice, you are signing and submitting this form under penalty of law. That means it is against the law to make a statement on this form that you know is false. So that's the form. There's absolutely no proof requirement in this form to supply to anyone, the courts or anybody, or the housing provider for that matter, that shows that any of this is actually correct. If this is, I'll go to the health issue first. I don't know a single housing provider in New York State that's trying to evict someone other than for non-payment. There may be some people out there that are trying to evict for a holdover case, meaning someone has stayed beyond the term of their tenancy and they now want them to move on. Either they're going to move in and occupy that unit, they have a different plan for it, maybe they want to sell the property. But aside from those few rare occasions that I've run into, every single housing provider I've talked to is looking to pursue an eviction for people for non-payment because they know they are people that have not been impacted financially. I'll go back to the examples for the folks that I know that I'm trying to evict that are on SSI or SSDI, disability or Social Security. These are not people that have been impacted financially. If anything, they're doing better because they probably received stimulus dollars on top of the fact that those government checks haven't seen a single interruption whatsoever throughout this entire process. So it all falls back to A, the non-payment. If people are truly being impacted by COVID, and we've got millions of dollars sitting in New York State to provide relief, and this $2 trillion package just got passed by Congress and signed by President Biden this past week, there should be more than enough money to address any of these issues in this declaration. And there should be a proof needed by a tenant to prove that they have in fact been impacted financially. So let's go to the courts. Let's use the courts as the avenue for people to come in and say to the judge, I've been impacted financially. Here's the proof for it. Now connect me with relief. I don't think anybody's going to push back on that. I know as a housing provider, I would prefer to take this list of evictions that I'm waiting to proceed with in court and toss them in the garbage or the recycling bin because we've been able to allocate relief for people. The problem is the people that are not paying rent oftentimes are not qualified for the relief. And that's the major crux of the issue. The other thing I want to touch back on is when they say here, and I'm looking at my computer to pull up the New York State website, is that Any residential eviction proceeding commenced on or before January 27, 2021 shall be stayed for 60 days. I started these on November 2nd of last year. They were immediately adjourned for 60 days. I finally got a court date of March 15th, which is far beyond 60 days from the date that I commenced the action, and certainly, I shouldn't say certainly, and now what I've received is hardship declarations for many of these folks that is now going to push this process out until at least May 1st, 2021. And there's absolutely no indication that that means that the courts are going to be open on May 2nd and ready to hear these cases, or that these hardship declarations and the provisions within it aren't going to be extended beyond that time frame. So all that to say, it's more of the same, but now we've got New York State sanctioning the ability for tenants to lie to housing providers and deny us due process. So as much as I've tried the lobbying effort over the last several months, and I've tried to speak to any legislator, be it local government, state government, or even the governor's office, to say we need to restore some sanity to this process, it became ever clear that that was not going to be the case. So this past week, a few housing providers, myself included, we commenced action against New York State on Friday, suing to get a temporary restraining order on these hardship declarations so that we can get access to the court and get in there and have the court do the due diligence that's needed to verify whether or not people have in fact been impacted financially, and if they're really in a position where they can't be evicted. I would like to think that it's going to be successful. As I understand it from the attorney that's handling the matter, the state has a deadline of March 25th to respond. Unfortunately, they did not grant us an immediate temporary restraining order against this law and the hardship declaration process. But that's what we're fighting for. So, I'm reluctantly excited that this is finally taking place. I've thought about this for several months of commencing an action. We were told forever that we didn't have standing, and with this provision, these hardship declarations, and that law that was passed, I do believe that we have standing, and I'm really optimistic, cautiously so, that the courts are going to recognize that we have standing as well. So that's the big update. I really wish that wasn't coming to this. I wish that New York State, I wish that especially those on the housing subcommittees within the Assembly and the Senate would bring some sanity back to it. But from what I can tell, they're just doubling down on the stupidity, and we need to fight now. So if you want to get involved, we're certainly going to need funding to fund this suit against New York. I'm contributing personally. All of the other housing providers that are plaintiffs are doing so as well. But it's going to cost a good chunk of cash. You know, they make it very prohibitive to bring suit against the state when it comes to, in terms of cost of doing so, and it's probably by design. But the time is now. We've lost too much money as housing providers in this state. I know I personally have lost probably close to 100,000. I kind of stopped counting a month ago because it was just really too depressing to look at. But I know that many of you are also experiencing it. So if you want to get involved in terms of pledging some support to this, I would really appreciate hearing from you, and we're going to need it. It's going to need to happen. And don't be fooled that this is somehow the war that we're going to win here. This is a very small battle. This is a very small milestone in a marathon that we need to run to restore sanity to the housing provider tenant relationship in New York State. And this is going to be the first of many, many small battles that we're going to have. And don't be confused that there's a monetary payout or anything like that. This is simply looking for a restraining order against that law and the hardship declarations so that we can pursue due process within the courts that have essentially locked us out so far. And with this is only going to make it that much worse. So get in touch with me. My website's richtyson.com. You go there, you can find any of the social media connections that you can connect with me there. Cell phone number, email, reach out to me. I need to hear from you. We need to fight this. We need to fight it really, really hard. And unfortunately, it's going to take us, despite having lost a lot of money already, it's going to take us forking up more cash to make this happen. And I look forward to bringing you updates, and hopefully we will prevail in the courts. See you guys soon. Take care.